Let everybody in. Morning, everybody. We're just letting everybody in for 2 seconds before we get started. Everybody's just starting to join us. Just be 1 second. Just before we get started, just so that everybody's aware, we'll be using the chat function today to post any questions for Chris and Michael. So if you just see the chat box just below at the bottom of your screen, just type anything you'd like to request in that box, and just make sure that when in the to field you select all panelists and attendees so that we can have a look at all the questions, and we'll answer them at the end of the session. So I'm just waiting for a few more people to join us and then we'll get started. Perfect. Chris, over to you.
Thank you, Victoria. Well, morning, everyone. For those that don't know me, my name is Chris Cook. I'm a partner and head of employment at SA Law. I'm delighted to be joined by Michael Salter, who is a part-time employment judge and a barrister at 42 Bedford Road Chambers. In terms of the format for this morning, Michael's going to be talking about the legal implications of restrictive covenants and employment contracts. I'll be talking about some practical considerations there. Each session is going to be about 20-25 minutes approximately. The entire session should be no more than about an hour, and we should have about 10 minutes or so, maybe 15 minutes for some questions at the end. So as Victoria said, there is a chat function you've got at the foot of your page, which you should be able to just pop a question in there if there's anything you'd like to ask us, which we don't cover. And as I say, we will do our best to answer those at the end. So I shall now hand you over to Michael.
Thanks, Chris. And welcome, everyone. As Chris said, my name is Michael Salter. I'm a barrister at 42 Bedford Row, and it's something of a poison chalice to be asked to talk to non-lawyers about particularly fact-sensitive legal disputes, as ultimately us barristers end up looking like we're permanently sitting on the fence and just giving vague advice as to, oh, well, it all depends. So much so that you probably think we're going to end up getting splinters at some point. However, this is particularly true, unfortunately, for restrictive covenants. However, that said, there are a lot of points that can, of general principle that can be taken from the law. And I'm hoping that when you leave today, you'll know what to look for in your contracts and your restrictive covenants. And it's my aim today to highlight to you potential areas of concern that mean when you go back to your business, you can look at your covenants and make sure they're fit for purpose, make sure that they maximize the protection that you can get from the contractual terms that you have with your employees. Now, that's really what I'm going to be talking about today. I'm going to be talking about restrictions upon trade between ex-employees and your business. I'm not talking about restrictions on trade on business sales or mergers. That's a totally different area of law and one that involves different concepts. Here we're looking at, as I say, at the restrictions an employer can place on their employee during the contractual relationship, and which survive the ending of that contractual relationship. Now, the contractual relationship comes into existence when an offer of employment is accepted, and usually there's a written contract that's been signed. Now, the first practical lesson is please do make sure that you get your contracts of employment signed, because if you don't, there are a whole world of pain will open up in front of you when you're in court or a tribunal seeking to justify the terms of your contract, which the employee will say, oh, I never saw that, I never signed it. So that's the first practical lesson today. Ensure your contracts are signed. The second point is that the terms we are looking at, although they have their foundation in that contract of employment, they only really come into effect when that employee has left. And it very well might be that that employee has not left in good circumstances. They may have been dismissed, they may have walked out with your database, they may have walked out with your client lists, and you want to restrict and stop them from taking an unfair advantage with that information. So We are dealing with clauses that I say act to restrict trade, or you may have heard it called restraint of trade. And when dealing with restraint of trade clauses, the courts are on the horns of a dilemma. There's obviously a public interest in people and organisations trading freely. Against that, however, there is an interest that such competition, which is a good thing, as Mary tells us, competition is always a good thing. It forces us to do our best. A monopoly renders people complacent and satisfied with mediocrity. However, against that, as I say, is an interest that such trade and such competition is fair, and that agreements are entered into are upheld. And there we go. So unfair competition. Unfair competition is a bad thing. Competition generally is a good thing. Sorry, I just pressed the wrong button there. Now, courts take a very strict approach when dealing with employees and employment contracts and post-termination restrictions. The starting point is that the clauses that you have inserted into your contracts seeking to restrict competition or whatever are unenforceable, and the court will need persuasion that they are reasonable and enforceable. And why is this? Well, it's presumes that the employee is considered to be the weaker of the two parties. They're in a weaker bargaining position. They need the job probably more than you need to offer them the job. So they need extra protection. For instance, there's unlikely to be any enhanced pay for the employee to sign up to the undertaking not to compete, and the employer is probably unlikely to promise not to compete with the ex-employee if that ex-employee were to totally legitimately set up a business. So how does the court go to obtain that balance? Well, it goes to obtain that balance, as a point I just raised a few moments ago, that they're presumed invalid, those clauses, unless the party seeking to rely on them, namely the employer, can show that they are reasonable. And the courts, don't get me wrong, the courts are not sympathetic to an ex-employer who gets that assessment wrong. Not only are there cost consequences for losing in court litigation, but even if the court has sympathy for you, even if the court thinks, well, the ex-employee did act unfairly in their post-employment behaviour, if the court does not think your provisions are reasonable, it is highly unlikely that they will enforce it. They will just say it's unenforceable. The employee, however in the wrong they are entitled to go out and make hay whilst the sun shines with their illegal, improperly obtained evidence or material. So, as I say, the fundamental point is to show that there is balance. So you have noted that my talk was Restrictive Covenants, or how to build a better burger. We are, sorry, I'm just got the wrong slide up there. There are, what we're looking at are the core parts of your business, so price lists, secrets, staff and customers, and the courts will aim to strike the balance, as I say, between restraining trade, which is bad, and the regulation of commercial relationships between the parties, which is good. We then come to the why burgers. Well, now that we're getting now onto the specific part of this talk and the factors that the court will look at when they come to assess whether or not your restraint of trade clauses, whether or not your restrictive covenants in your contracts of employment are reasonable. And when I was writing this talk, or thinking about this talk, I got to think about how would I explain the role of the court when assessing these clauses, and I got to think of something that's very close to my heart, and burgers it is. My wife often criticises me, as she knows that if there's a burger on the menu wherever we're going, then I'll probably be ordering that. Now, whilst I think consistency is a virtue, my wife may take a slightly different view when it comes to my culinary habits. Now, Burgers, why burgers? Well, you could go and buy a ready-made burger that will probably be serviceable, it will be nice, and on its day it might be perfect and just what you need. However, equally it may leave you underwhelmed, and in civil litigation that's a very big risk, particularly with restrictive covenants. As I said earlier, and as the point in J.A. Mont in the second of those bullet points that clearly expresses, the real sanction at the back of these covenants is the terror and expense of litigation. There's added terror that, as I said earlier, the clause may be unenforceable, so the ex-employee can do what they want with your information or your clients. Then, to add insult to injury, you may be required to pay damages to the ex-employee if you've obtained an injunction at an earlier stage in the process, but then that's not shown to be enforceable, or your clauses aren't held to be enforceable later on at the trial. Against that, if you are successful, you'll get your costs, or the presumption is you'll receive your costs paid by the other side. You may stand to receive lost profits. You could get damages for the cost of retraining staff. You could get an injunction to prevent the use or further use of the information that's been taken away from you. And you've got, or the court has powers to require the documents and information to be returned to you, and undertakings given to the court to ensure that the information is deleted and not retained by the wrongdoer. So it's that reason that I've given you Salter's Invent a Burger competition. Basically, for me, the perfect burger has three key elements. Firstly, the burger itself, be it chicken, beef, ham, vegetarian, vegan. That's the core of the burger, or in this context, it's the interest that you are seeking to protect by your covenant. The second element of the perfect burger is how you deliver that filling. What are you going to use to hold it all together? Is in the burger sense, it is the bun. In the legal sense, it will be the actual clause itself. There are various clauses that we'll come and have a look at in a few moments that can seek to protect and advance the interest you are seeking to protect. Finally, there's the garnish, the relish, the cheese, the sauce. Often it's overlooked, but it's a very key ingredient to complement it and propel the burger from being a slab of meat or vegetarian or vegan burger in between two bits of bread into the gastronomic delight that you want. Now, these are the parts that the courts tend to focus on. These are the parts that the courts will dissect in detail to see if the covenant is reasonable or not. So let's look at how you'd go about creating your perfect burger. Firstly, you'd need to identify the interest, the filling, the burger itself. And you can see up there, I've identified, traditionally they're identified as three. Generally, this must involve, let's say, some identifiable advantage or assets that can largely be regarded in a general sense as your property, which it's unjust to allow the employee to benefit from, even though they may have helped themselves to produce it. So traditionally, there are three: confidential information. So all that information you've taken years to build up, price lists, contact details, business needs of clients, when their contracts are coming to an end, all that sort of material is probably going to be considered confidential. The second of those elements are customers themselves, their contact details, their names, their phone numbers, all that sort of information. Finally, there's stability in the workforce. You've built up a team, you've molded that team to what you want. You've got the right people hopefully in place, and you're very happy, very content with that body of people. The last thing you want is a disgruntled employee walking out and then poaching all your staff. So those are the three traditional interests that the courts seek to protect with restrictive covenants. But they're not closed, and we're starting to see a bit more interest in the protection of suppliers. Particularly if it's a limited supply, So your supplier is the only person who supplies a particular widget, for instance. Then if you were to lose that supplier, and if they were to be taken from you, that would obviously have a massive impact on your business. The flip side of that is if you could easily go out into the marketplace and buy the same item for the same value and the same quality, then it's unlikely you would be able to protect your supply chain. So we've got the burger. The next slide is the bun. And so how do you want to go about protecting that interest? So what are the interests of the parties and how you go about protecting them? Well, trade secrets and confidential information, there's issues as to how you go about policing that. How can you positively show that your ex-employee has gone and disclosed confidential information? Quite often then you see, if your aim is to protect confidential information, you'll have a non-compete clause, because that's a lot easier in theory to show and to prove that the employee is competing against you, and you don't want him or her competing against you because of your confidential information. There are other rights that you'll have over your confidential information, and there's implied duties of confidentiality, and there's database rights. But as far as strict contractual terms are concerned, quite often if your concerns are confidential information, then the non-compete clause is the correct or the better, should I say, way to protect those. It doesn't matter how the ex-employee came into possession of that material, even if they obtained it innocently, even subconsciously, then that information is confidential and can be protected. When dealing with customer connection, so the second or the top of the burgers, the clauses that quite often are used to protect that interest are solicitation. Now this has a very special meaning for employment lawyers, and it indicates some sort of encouragement by the employee. Now quite often, again, evidential difficulties can arise as to how can you show that the employee has made the first step. So quite often there's a non-dealing clause, which you see third up or third down on the bun. So which basically means they just cannot have contact with or deal with the client. Connection, or both of the non-dealing particularly involves connection, and which is a concept that has various shades. At one end is a close connection that the employee has built up over a number of years with in-depth knowledge of the customer and their needs. Perhaps to the middle of that spectrum is a director who has less direct contact with the client, with the customers, but knows the customer's business. Now that might justify a non-solicitation clause, but not a non-dealing clause. At the other end of the spectrum is a member of the team which doesn't deal with the customers at all. Now, chances are you will not have a valid non-dealing, non-solicitation clause, because if you had one of those in that sort of person's contract, because there was no connection, there was no real interest, and there was no risk of that employee stealing those, unfairly taking those customers away from you. I've referred to it before, and it's the non-compete option. This is widely seen as the nuclear option. However, it is the best option if the identity of customers is not known. So, for instance, hairdressers are a classic example, and you'll be surprised the amount of litigation that arises out of hairdressers. Quite a lot of their business walk in off the street. They don't have long-standing agreements or arrangements with the hairdressers. Just walk in as and when needed. So a non-solicitation, non-dealing is not really going to work. A non-compete clause, however, will. The employee agrees not to compete with the hairdressers once they leave. Next, stability in the employer's workforce. Non-poaching, think of that as solicitation for fellow employees. Your ex-employee shall not go and take other members of your staff. Slightly wider, or considerably wider, are the non-employment clauses. That's very similar to the non-poaching, or it's very similar to the non-poaching clause, but and are unlikely to be enforceable widely, because it's often seen as restricting a person's opportunity to move work and obtain better employment, perhaps totally legitimately. So the first lesson from this is make sure that your interest that you're seeking aligns with the method of protecting it. So quite often there are lots of examples in the case law where an employer has expressly sought to protect an interest and used the wrong sort of clause. For instance, recruitment agencies are another rife source of this case law on this area. Quite often, there's a number of cases where they've used an area exclusion. So an employee shall not work within 6 miles of the office, to protect against non-competition clauses when the clients were national, or when those clients used telephones or the internet in order to make bookings. So their geographic location had absolutely no bearing on the clause. The person could have been 7 miles outside and still taken the work. So there was a non-alignment there between the interest and the clause. And you might think that this was an attempt at the at that court by the employer to try and justify and shoehorn in a right to the clause that they had in their contract that perhaps didn't work. So that we've got the bottom layer of the bun. We now move on to the relish. So the questions for the court will be, as I set out there, who, what, how long, the level of involvement, consideration, the legal costs that must be paid, and when. The court will ask itself, is it wider than reasonably necessary? So if there's too much sauce, then it will overwhelm the otherwise perfect combination of a filling and a bun and make it unpalatable for the court. And this is where us lawyers run the risk of, as I said at the outset, getting splinters, as it's all incredibly fact sensitive and dependent on the particular situation in any given case. But what I think I can say with little risk of contradiction is that a one-size-fits-all approach is unlikely to work. The court's key concept will be reasonableness, and they also look at what is no more than reasonably necessary to protect the employer. To protect the employer's interest. And as I said, the burden of proof, who has the obligation to establish it, is on the employer and not to the employee to show it's unreasonable. Now, whether the problems arise in non-compete clauses, quite often they can be drafted widely, not to compete with any other business that rivals the employer, or narrowly they can prohibit the joining of a competitor in a particular field. These can be weighted against the right to be protected. So ask yourself, what is the right to be protected? Confidential information, as I said, is difficult to police confidential information, and so non-compete clauses can be more likely to be upheld in confidential information cases, as opposed to just when you've got an employee who has left and you might be disappointed that they've left. When's it assessed? Now, it's assessed when the contract was entered into. So a real danger are long-term employees who have built up a number of years service and have worked their way up the hierarchy. Maybe they started as a junior salesman and they've got a contract, and now they are a sales director. The reasonableness of those restrictive covenants that are in their contracts will be assessed on the day they joined as a junior salesman. And if they're unreasonable, then that's the end of the court's inquiry. Tip then, every time you have a promotion, get the person to restate their covenants in the new contract and support it by some sort of what lawyers call consideration, a price. So a nominal sum, £100 to restate those restrictive covenants. What other factors? Geography, is your business localized? If so, it may be valid. If not, then it's unlikely to be a valid restriction or consideration. Equally, is the entire industry centralized in a location? Insurance in this tradition in the City of London, for instance. If you're excluding someone from 2 miles, whilst that's not a huge geographic area, it effectively excludes them from their business totally. When also thinking about geography, don't use such phrases such as areas the companies conduct business, and that simply doesn't work. That's not clear. Set out perhaps in a map what areas you're saying this person is excluded from working in. If you don't have a geographic exclusion, it is presumed that the person is excluded from acting or competing in the entire world. Now, there's case law involving Dyson, the Hoover company, that upheld a worldwide injunction, though, because there was a clear definition of competing, and Dyson's industry was worldwide. Point I've touched on earlier, think of where your clients come from. One technology means probably a geographical exclusion is unlikely to be of very much assistance. And again, think of the area. 5 miles in the country may be reasonable. 5 miles in the city is unlikely to be reasonable. Think then the level of involvement, said consideration, when assessed, what is prescribed, what is stopped. Customer contact. Can you really stop customer contact? Yes, you can, but it has to be clearly delineated to that sort of contact that the customer, the employee had with the customer before they left. You're not, or you're unlikely to get an injunction stopping an employee contacting or having some sort of contact with clients generally. It really has to be those sorts of customers that they had contact and influence over, perhaps for a defined period of time prior to them leaving the employment. Now, moving on then to severance. The courts in the UK have very limited powers to rewrite contracts. Frankly, they just won't do it. What they will look at is whether or not they can blue pencil certain words from the agreement and keep what remains and ensure what remains is sensible, is logical, and seeks to protect the interest that you started out seeking to protect. Sorry, I just realised I haven't built my burger. They cannot reduce the scope of a clause and impose effectively a new clause on the parties. All it can do is sever part of the clause that are too wide and leave in place those parts of the terms that are acceptable. If that's done, then what remains doesn't need an amendment to the and what remains doesn't need an amendment to the wording. The removal does not generate any major change in the overall effect of the restraints, and what remains is not against public policy, i.e. it is reasonable. Finally, repudiation. This is a real trap for the unwary, and a real and it's a battleground that is very well visited by employees. I'll give you a classic example. Employee walks out, says, I'm going to treat myself as constructively dismissed, i.e. the employer, you've done something so bad to me that I'm unable to remain at work. If that is right, then the contract is at an end and all contractual obligations, the parties are discharged from their future performance of the contract. So all the good work done with the drafting and the enforcing of a covenant is lost on a constructive dismissal, as restrictive covenants do not apply. Now, the concept of repudiatory breach acts both ways, and there are a number of times that unwary employers have been the victim of a repudiatory breach by the employee, and have accepted the employee's repudiatory breach, therefore meaning the employee themselves gets around their restrictive covenants. So if you are faced with an employee in repudiatory breach, I don't know, gross misconduct, the best thing you can do is not to accept the repudiatory breach, but to act appropriately and reasonably and go through your disciplinary process. What are examples of repudiatory breaches that employers often fall into? Well, attempts to renegotiate fundamental clauses of contracts. Then we have pay. If there's issues with pay, that can amount to repudiatory breach. Changing of contract, changing of jobs and roles. All of these can act as repudiatory breaches of contracts that can ultimately lead to the employee taking your information, walking out the door, and getting away with it. So that is something of a whistle-stop tour about the three fundamental points that you need to take away, hopefully, from my part of the talk in relation to how to build a better burger. So now I shall pass you over to Chris, who's going to take you through the rest of today's talk. So thank you, Chris.
Thank you, Michael. It's always tricky following barristers, isn't it? I haven't got any burgers to offer you, I'm afraid, which is always slightly disappointing, but hopefully my talk will still be interesting. I just checking that the screen is working. Victoria, I think, is in the process of sharing her screen. Just give us
1 second.
Okay, thank you. Yes, on this slide is a bit of a summary of what I'll be talking about in my session. As I said, it's going to be the practical considerations for restrictive covenants and employment contracts. Really, it's going to be three main areas. It's number one, taking steps to avoid breaches occurring in the first place, how to detect breaches as and when they occur, and then what to do following a breach, just so that we've got a bit of an overview about really trying to prevent the situation really coming up in the first place. So just going on to the next slide. Well, as Michael has talked about there, the starting point really for you to take action is the employment contract, how well it's been drafted, whether it's been properly incorporated, etc. But that doesn't really address the issue about why the breach has occurred in the first place. So it's important just to take a step back, I think, just have a think about what's led to this situation, because once you've had it happen once, you really want to avoid it happening again. So why is your employee looking to breach their contract? Don't forget there is effect here, not just in terms of the damage caused by the employee, but don't forget who they're leaving behind, the team that they've left behind, that the employee morale is going to be affected. They might find some clients are leaving the door as well. So it can be very demotivating for a lot of people who are working with the employee who's leaving. Lawyers are, of course, paid to look into the legal issues, but on this slide, I'm asking you to have a look at some practical considerations as well, such as what's motivated them to leave? Were they supported? Was their career progressing? Did the business structure give them a path forwards? If an employee progresses to a more senior level, that potentially creates some additional statutory and fiduciary duties, for example, under the Companies Act, also certain fiduciary duties as well, which are implied. What I'd suggest that you do is when members of staff become more senior, try to add their more onerous restrictions to their contracts, because as Michael said earlier, you only look at the contract at the time that it was signed. So if someone's been with you for 20 odd years, for example, and they're on a junior contract and they've progressed to managing director, you're looking at the terms as they were when the contract was signed, not when the employee leaves you. So just make sure you're reviewing your contracts and getting them updated and changing them appropriately. It has a dual benefit of allowing the employee to feel that they're progressing, as well as creating additional duties, which gives your business more rights to enforce if they choose to resign at any point. Another perhaps slightly less obvious issue is, does the employee have a work-life balance? We act for both employees and employers. It's often the case that employees who are leaving just simply say, well, I didn't really have a work-life balance, I wasn't enjoying it there, so I decided to leave to go to a competitor. What I'd say is you do need to check in with your staff regularly. It's particularly important during the lockdown because obviously there's less face-to-face contact with your staff, but you should still be checking in, making sure they're happy, making sure that any issues that arise are dealt with promptly. Interests outside of work are often looked at with a bit of skepticism by employers, but it could be in the form of a hobby. For example, my colleague Lizzie, who actually helped me prepare these slides, is a baker, and she finds it quite therapeutic in a lockdown situation to bake, in her spare time. But interests outside of work could actually be business interests as well. I think you should really support staff in having business interests, provided, of course, it doesn't compete with what you're doing. The employees being transparent about what it is that they're doing as well, and it's all obviously in their own time. For example, at SA Law, one of my colleagues runs an animal support charity, another one runs an online dog food shop, actually. So quite diverse interests, but clearly don't compete with what we do at SA Law. Another key thing to secure your staff is to offer long-term incentives, which is very important in terms of encouraging them to stay on. And that could be in the form of, for example, a share option scheme, bonuses, maybe accrued annual leave, which increases with length of service, sabbaticals as well, maybe offering that after a certain length of service as well. That could be very helpful in terms of minimising commercial risks and avoiding competition. These sort of things could be implemented fairly easily, and I'd certainly strongly recommend them wherever it's possible. Certain sectors, it's not possible to do that, for example, finance and pharmaceutical, but generally SME businesses are pretty much free to do whatever they wish in terms of bringing in long-term incentives, which should reduce the risk to your business. So what about detecting competitive behaviour? Well, you need to be very much alive to the risk that employees might look to leave you at any stage. People have been generally sitting tight over the last few months, but obviously things are starting to change now. People are starting to think about moving again. But what sort of things you can do to detect competitive behaviour very much depends on the type of business that you've got, how it operates, the type of competing activity involved, and of course your resources to keep an eye on your staff as well. I think it's inevitable that some sort of monitoring of staff is going to be inevitable. There are, of course, some dangers of doing so because it could create a bit of a culture of distrust. And if it's not done properly, and Michael alluded to this earlier, but you could unwittingly breach the implied term of mutual trust and confidence between you and the employee, which could have the knock-on effect of actually voiding any restrictive covenants in their contracts and then freeing up the member of staff to go to join a competitor. One option you've got for monitoring is setting up CCTV, but I'm not a big fan of that, to be honest with you. It's quite extreme. It doesn't provide much information, actually, because all it will really show is whether someone's actually sitting at their desk rather than what they're actually doing at the desk. And it, again, doesn't help with the culture of distrust point I mentioned earlier. More helpful form of monitoring, in my mind, is to monitor things like employee telephone calls, email correspondence, photocopying, printing, etc. It's easier to tell if inappropriate conversations are occurring through obviously monitoring telephone calls, but you do need to have a clear monitoring policy. And it's not just having the policy, it's also being very clear about what you're monitoring, how you're doing it, and the reasons for doing so as well. You can dress it up to a certain degree. For example, with phone calls, you can say that the reasons are to ensure a high standard of customer care or to improve the service that we offer. I think that's the message on our own department's call recording system. And just to reassure you that I'm not trying to keep an eye on my own staff by recording the employment department's calls, but it is a certain degree, you can keep it quite broad in terms of the reasoning so that you're not actually using the recording for a different reason than what you're saying that you're using it for. There are, of course, some data protection considerations here that do need to be borne in mind when monitoring staff. What I would just say is that they are quite complex and could actually be a whole webinar in themselves. But before you do any monitoring, you may have to consider at the very least doing what's called a data protection impact assessment, just to balance the risk of doing the monitoring against not doing it and things like Human Rights Act issues, etc. Just to make sure that you've properly considered all angles before you go ahead and do it. Really, what I'd just say is that in terms of monitoring phones, there are actually other regulations that come into play as well. So all I'd say to you is before you look to do any monitoring, just be alive to the potential risks there and seek advice from someone like myself or Michael as and when you need any assistance on that side. So in terms of the telltale signs of competitive behaviour, well, I've listed a few on this slide here. Basically, some of these would be fairly obvious. Some of these are not so obvious. And perhaps with the benefit of hindsight, you may look back and think, well, yes, maybe I should have spotted that. So let me just talk you through a few of these. Firstly, the employee actually requesting a copy of their employment contract is in itself a sign that there might be something untoward going on. On its own, it's probably okay, but if there's a number of them happening to come in within a short space of time, the alarm bells really should be ringing, because it might be an indication that it's not just one member of staff who's looking to go, but possibly a whole team. If an employee changes their work patterns, for example, begins starting early or finishing late, or there's some unusual requests for time off work, that again might be a sign that things are not going smoothly, and they might be looking to leave, possibly attending interviews, possibly meeting up with other people. Look for changes who the employee is socializing with as well. It's actually very difficult to obviously monitor that in a lockdown situation, but if the team is starting to socialize together or set up some group chats or group emails on a messaging platform, that could be quite a dangerous sign, actually. You can't actually monitor an employee's personal mobile phone, but if an employee does start mentioning things like a group chat having been set up, I would try to explore the purpose behind that, because it could be quite negative sentiment being expressed there, and worse still, it could actually be an indication that they are maybe looking to set up on their own together or to go to join a competitor. Another big issue I tend to see is things like the usage of personal email addresses for professional work. I'm a big advocate about not allowing personal email addresses to be used for your business at any stage, really, because it's a great opportunity for employees to start sending confidential information by email to themselves in a personal context, which can then be sent on to various different other people as well. The excuse is often given that they need to work from home. And of course, remote working does pose some dangers and creates great opportunities for staff to do untoward things. So what I'd say there is that just make sure you've got a proper email and IT systems policy, but not just have the policy, make sure you're policing it, keeping an eye on what's happening. And if you are aware of anything going on which is untoward, do take action where appropriate. It might be a disciplinary matter. Hopefully a shot across the bows, and just a reminder to staff about not to do certain things should be sufficient. An employee has resigned. I've just mentioned exit interviews could be a very important thing to just try to use for various reasons, actually. You can find out certain things in there, such as what are their reasons for leaving? Are they willing to disclose who their new employer is? I would just quickly say you can't be too heavy-handed, because obviously if you are overbearing to a point that the employee feels that they've got no alternative but to immediately resign, it could actually be a fundamental breach of contract on your part, and as Michael said in his talk, could actually void the restrictive covenants in their employment contract. So do be careful about how they're managed. But there are useful opportunities to remind staff about their restrictive covenants. What I'd probably do on the back of an exit interview also is put it in writing as well, just that reminder about the fact that there are covenants in their contract, and it's a useful shot across the bows just to remind the staff that you are keeping an eye on the situation. If you're still concerned, you can actually ask the employee to sign written undertakings. The trouble is, of course, by the time they've resigned, you're actually in quite a weak bargaining position to get undertakings signed. And undertakings really are a form of a covenant, which is basically both parties acknowledging and agreeing what the employee can or can't do. But if they refuse to sign that undertaking, it is, of course, an indication that breaches might already have taken place. So what recommendations can I give you to protect yourself from competitive activity? There's a few things I've mentioned in this slide here. So firstly, ask the employee to create an activity log, daily activity log, or you could perhaps do that yourself. That can create a clear footprint of what's happening with your clients, for example. It's not an unreasonable request, but it does need some justification. So, for example, in a lockdown situation, you may say to your staff that you'd like to introduce this to ensure effective home working, particularly for sales staff who can pretty much dictate their own diary and sometimes don't communicate very well what they're doing. You do need to think about updating your procedures, though, because obviously when it comes to home working, you should really be thinking about a general home working policy anyway. But a daily activity log is the sort of thing which I'd like to see reflected in the way in which you work, even if it's just on a temporary basis during the lockdown situation. Daily activity logs are actually quite easy for solicitors and barristers to do, because we actually charge an hourly rate and are well accustomed to time recording, but others might find it quite tricky to do if they haven't been used to it. It is, however, worth sticking with, because if someone does resign and you are able to look back over the last few weeks about which clients they've been working with, it's a really useful barometer to tell you where to focus your efforts in terms of protecting your business once an employee's resigned. Try to also ensure that employees are only using your document management system and company equipment. So in other words, just your own IT. There is, of course, a cost involved in that, but a paperless document management system is much easier to monitor than hard copy documents, which really could go anywhere. Having a separate work phone really avoids any excuse for customers to be contacted on private mobile numbers, and very much restricts the ability that employees have to forward confidential information where it shouldn't go. If possible, try to have more than one employee working with each customer. That really does limit the opportunity for competitive activity to arise, and can greatly assist with any investigation into a possible breach that might have occurred. You do, however, need to encourage employees to come forward and report breaches. And if, of course, 2 employees are in cahoots together, well, that's going to be limited in effect. But as I say, it is a good safeguard to have more than one person working with any key customers in particular that you might have. As I said already, you do need to get your policies up to date. You need to permit monitoring. Do deal with things like working in the pandemic and remote working as well. Social media is another thing which is particularly important, and LinkedIn is one of the key ones there. It's very important that you think about this when an employee leaves, because they will have contacts on their LinkedIn page. You can actually require in a well-drafted social media policy, and better still in the employment contract, to require employees to disclose which customer contacts they have on LinkedIn, with a continuing duty to disclose that information. And going one step further, you can actually ask them to remove that information once they resign, if you've got a well-drafted social media clause. So do think about the employment contract drafting there. One or two other practical steps you can take to protect yourself. Well, you can ask employees to take periods of holiday. As some of you probably have realised during the lockdown situation, you can actually serve a notice on employees to require them to take annual leave. That could be a useful opportunity. You have to review their activity while they're not physically working with you. You can also ask for things like phones and laptops to be returned. You can block access to IT systems, but please make sure you've got the contractual right to do it before you start doing it, because as Michael said earlier, one employee, when they look to resign, is looking for an opportunity to say it's a constructive dismissal situation. So if you start doing that sort of thing and preventing them from doing their job in circumstances where they've just resigned, it might actually give rise to a constructive dismissal situation. So please be careful about making sure you've got the contractual right to do it before you go ahead. One final thing, which is often overlooked, is just making sure you've got access to a forensic expert or an IT person at the very least, because if there is a breach that comes up, generally it's going to be an IT related breach. So you need to have someone on board quite quickly, potentially, who can step in and help you investigate this promptly, because even leaving it a few days, the damage could already be done. You need to have someone on board very quickly. So do have a think about who is able to step in and help you out if there is any breach that arises and you have to take action very promptly. So just going on to some additional contractual protections available. I've alluded to some of these already, but think about having an express garden leave clause. It is important to have that in there because it does eliminate the risk of the employee trying to argue there's a duty to provide them with work. So, you know, for example, otherwise you might have an employee who resigns and then physically have to carry on working with you throughout their notice period. It's also very helpful while an investigation is underway into possible breaches. And do bear in mind, a garden leave clause doesn't have to be solely after an employee has resigned. You can actually enforce a garden leave option even before someone's resigned if you can suspect, for example, something untoward is going on. It can also be a useful option to help delay an employee going to a competitor, particularly if you're concerned about the enforceability or restrictive covenants. Also, just make sure that your contractual disciplinary and suspension provisions are up to date. Make sure the disciplinary provisions do cover things like leaking of confidential information, and make sure you've got a contractual ability to suspend as well, because obviously you may have to enforce that if you suspect that some breaches have happened during their employment, and it might be before or after resignation. Do think about adding additional protection into manager and director contracts. Michael's alluded to the one-size-fits-all approach not being a good approach, and I would agree with that, because you really don't want your, you know, for example, your receptionist to be on the same contract as a managing director. That tends to be frowned upon by courts, so it might make the whole thing unenforceable. So when people do move into promoted roles, try to get them onto more comprehensive restrictions. Bear in mind, of course, your key staff will have access to important confidential information and are much more likely to be poached by competitors because they see value in that, of course. And one final thing just on this slide is just be clear about what confidential information actually means. This will vary upon the type of business that you've got. but if there's not a clarity and you're very clear about the scope of what that means, then it will act as a deterrent for that information to be sent somewhere it shouldn't be. So what do you do if someone has resigned or someone's threatening to leave? Well, a few options I've just mentioned on this slide here. You could try to persuade them to stay. Doesn't seem the most obvious thing. Your initial reaction might be to say, well, get rid of them as quickly as possible. But there might be some reasons why you are looking to keep them in the business. And that's maybe because you haven't got your house in order. So in other words, you haven't got monitoring policy, you haven't got a social media policy, for example. And persuading them to stay, possibly with a salary increase, might give you a bit of breathing space in terms of allowing you to just get your policies, contracts in place, give you a bit more protection if they do happen to leave in a few months' time. There was actually a recent statistic that suggested anyone who's been persuaded to stay, more often than not, still leaves within the following 12 months. So that's not a great sign. But as I say, a bit of breathing space might be a good idea if you feel a bit vulnerable at the time they initially resign. I've said before you can put staff on garden leave, but do make sure you've got an express contractual provision that gives you the right to do that. Otherwise, it could be, again, a possible constructive dismissal situation that you might get into. If there's a disciplinary matter, always consider suspending the employee in circumstances where restrictive covenants have been breached. Again, this gives you a bit of breathing space to properly investigate while the employee is not in circulation. It can help to reduce the emotional aspect as well. But you do, of course, need to have the contractual rights to suspend, failing which, of course, you might slip into a constructive dismissal situation, as I mentioned earlier. One other point, which I haven't really covered yet in too much detail, is where personal data has gone astray, you can make a report to the Information Commissioner's Office, the ICO. Just to be clear, that's only when personal data has gone somewhere it shouldn't have done, because the data protection laws really apply insofar as personal data is concerned. The significance of this is that the ex-employee could actually face criminal proceedings for data protection law breaches. So it's often quite a good stick to beat an ex-employee with, particularly if you're concerned about enforceability of covenants generally. You may also find that the information that's gone somewhere it shouldn't have gone might belong to your clients, and they might be very concerned about what's happened with their data. So, as I say, getting the Information Commissioner involved may be helpful there, although do bear in mind the Information Commissioner might investigate, and there could be a certain degree of criticism of your organisation as well for not having safeguarded that data. I've mentioned three other options there. Seeking injunction, there's a possible claim for damages, and undertaking can be entered into as well. We will be having a separate webinar session from the litigation team that will cover this in more detail. Just going on to undertakings on the next slide, I'll just comment briefly upon this, because undertakings are often ways of resolving a dispute before we end up in court. And in fact, most restrictive covenant disputes tend to be resolved in this manner. However, if an employee does refuse to sign them, it tends to be a big warning sign that clearly something untoward has gone on here. But getting them signed does actually help to avoid any possible future arguments about the enforceability of the restrictive covenants. For example, the initial draft was too wide, because by reaffirming the covenants in the undertaking document, and just to be clear, an undertaking really is a document which really records both parties' requirements, so what each party is required to do, that will really just help protect your business. And as I say, it's often much more cost effective to enter into undertakings with an employee who's leaving, which may also involve their new employer as well, than taking the chance in the courts, which of course can be very expensive and uncertain as well. What I would just say about undertakings is that don't be complacent about them. You do need to make sure that they're well drafted and concise, so that both parties know exactly where they stand in terms of what they can and can't do after an employee leaves you. And just finally, one thing I just wanted to cover was what to do to respond to threatened proceedings. Let's just say you've taken on an employee and that employee has been accused of breaching their covenants. What are your options? Well, essentially, they are to fight a possible injunction if you believe you've got a good defence, or to give undertakings where you consider that appropriate. As I say, generally, undertakings tend to be given. And really the best option has to be considered on a case-by-case basis. I can't really give you advice now as to what your right option is, because it will depend upon the factors which I've put on the slides there. So I'd recommend you get specific legal advice if and when that situation arises. And do bear in mind that you may have to consider making an admission if there's a strong case against you. which might lead to undertakings. Conversely, though, if you've got a strong argument that the covenants are unenforceable, it could be worth a lot of money to your business if you're able to contest the validity of the covenants if a member of staff comes across to join you. So just to conclude then, thank you all for listening. Michael and I are happy to answer any questions. We've got for about 3 minutes now, so I'm not quite sure how much time we've got. But I will just quickly mention before I close that there is going to be at least one other session that we have, which will be the litigation process. So we'll start talking about things like, the court process, getting an injunction, a damages claim, and my colleagues Tracy Lacey-Smith and Robert Ryle will be running that in due course, and some more details will be circulated separately.
Thank you very much, Chris and Michael. If there's any questions from anybody, feel free to share on the chat function. Otherwise, I think, Chris, you mentioned a question from somebody who couldn't attend previously. Can you still rely upon restrictive covenants if an employee hasn't signed and returned their employment contract?
Yeah, I think Michael covered that point at the start, didn't he? But because really you've got to have clear evidence of the fact that the contract has been entered into. I suppose I have known situations where an employee has been given a contract, had it for 5 years, never objected to it, and the employer, that employee happened to resign, did argue that, well, because you never objected to it, those covenants are binding because everything else in the contract had been honoured. But the trouble is, of course, they don't really come into play until after the employee's resigned. So I always feel uncomfortable with an unsigned employment contract because there's no clear evidence of acceptance of the terms of the contract. Now, this is a point that Michael was saying earlier. Did you want to add anything there, Michael, just in terms of your view about unsigned contracts?
No, they say they just open up a whole world of pain for the employer seeking to justify them, justify the restrictive covenant. You do need clear evidence, and questions come in on the chat about what's the view of electronically signed contracts. I see no difficulty with those at all, provided the provenance of that signature can be proven on the contract. And so I wouldn't put it past some litigants to say that's not my signature. I don't know, my dog did it whilst stamping all over the computer. So I think provided you can establish the provenance of where the signature came from, it's not a problem, but you do need that signature, electronic or otherwise.
Yeah, and I'll just quickly add that insofar as document completion in a lockdown situation is concerned, obviously electronic signatures are becoming quite common, and the context of it will be quite important as well. I mean, if there's a dispute about where the signature has suddenly appeared from, that I can understand, but generally there's some sort of email context to it as well, making it quite clear that the other party has intentionally put their signature onto a document to confirm their acceptance of it, and that will become useful sort of circumstantial evidence, shall we say, of the fact that there's clear evidence of agreement there. I have known one.
Just feeding off that. When you receive an electronically signed contract, just fire back a reply email saying thank you very much for the contract that I see has been signed. And then if years down the line that person says I never signed that contract, you can put out the email confirming it. That was never questioned. So it's topping and tailing it on both sides, as Chris says, context leading up to the signing of the contract, and then equally valid, I think, after the contract.
Yeah, absolutely. I've just got another question, and that is, if an employer is made aware of a potential breach of restrictive covenants by a new hire with their old employer, how should they deal with this? It's a good question, actually, because I suppose it depends really on the extent of the breach. The one that I'm always most mindful of is the restrictive covenant breach insofar as non-compete is concerned, because Michael, I'm sure you'll probably agree with me that the one that's most debatable in terms of enforceability is the non-compete provision, particularly if you've got other provisions in there, such as non-solicitation, non-dealing, which give the business arguably enough protection anyway. So if you are a competitor of the former employer, immediately you've got a problem there potentially, haven't you? Because generally speaking, that's the sort of thing which arguably is a restraint of trade, but technically also is within the scope of the restrictions. What I often see in that situation is we often negotiate a resolution whereby they can carry on working with you. So in other words, they effectively waive the non-compete provision, but all of the other covenants are reaffirmed. So I've often seen undertakings done on that basis because the former employer really wants to protect itself in respect of losing its customers, for example, and of course its staff as well. And as long as undertakings are signed on that basis, they generally are fairly flexible about allowing the ex-employee to go to a competitor, particularly if they're quite pigeonholed in what they do. And in that situation, they might not be able to get another job at the same salary unless they go to a competitor. But it does depend on the circumstances, is the honest answer. I think that non-compete provisions are the most contentious aspect there. But if the whole reason you brought them in is because they're bringing a book of work with them, that is quite a major problem, and it might give you rise to think, well, maybe I should terminate the contract because I'm not going to get any value from this at all. You need to think about also what the conditions were of that a new employee starting with you. You may have made the offer conditional upon them not having any restrictive covenants, and suddenly you find out 2 or 3 weeks later that is the case. If they're on their probationary period, it's actually relatively easy to dismiss a probationary employee, particularly if you think you're going to end up in a high court action when they're breaching their covenants. So yeah, difficult one to answer succinctly, I suppose, but first things first, I think you've got to just see what the covenants actually are, see how likely it is that they've been breached, and then devise a strategy around that, I think.
Yeah, I think that's entirely right. The risk also that the incoming business or the new employer has is they could also find themselves in hot water on breaching contracts, inducing a breach of the employee's contract. Something Chris said in his answer was, if you're able to have that employee work or reaffirm the restrictive covenants, another option might be to have that person work for a short period of time in a totally different aspect of the business. I did a case involving solicitors' firms and a solicitor moving from one firm to another. The firm to which the solicitor went was large enough that they could put that solicitor in a different department, and they worked on business development for the period of their restrictive covenants. So gained that employee a little bit of work and gained both employers protection from litigation.
Yeah, that's a good idea. I think one thing I would just quickly say is that courts tend to be quite wise to any hidden work, because it's often the case that someone else fronts up the work, whereas in reality it's been undertaken by the ex-employee. And if it's a well-drafted restrictive covenant, it often covers directly or indirectly dealing with clients. So that might be a solution, but as Michael said, the better option is just really detach them from those clients completely for a period of time, wait until the restrictive covenants are passed, and then they've got free, well, I say free rein. Be mindful that confidential information obligations do apply indefinitely, but subject to that, yes, generally after the covenants have expired, you should have an easier job there, I think. I think that is the questions answered. I'm also mindful of the time. It's just gone 11 o'clock, so I apologise for a slightly overrunning. But if you do have any other questions, feel free to drop Michael or myself an email. We will be around. There is going to be at least one separate session from the litigation department on the actual court process, which I haven't really had time to go into today. But can I just firstly say thank you to Michael for his time this morning. Always difficult following Michael, particularly when he's got burgers on offer, but I certainly find it useful, and hopefully you did too. And hopefully we'll see you again very soon at our next session.